Good afternoon, and welcome to the holiday version of the Baylor Executive LLM and Litigation Management's monthly roundtable. Because it is the holiday season, we thought that we would try to give you a few gifts that might help you as you go along. So, when we talk to people about practicing law these days, a couple of things come up. People are stressed. They're under pressure. They're under pressure from their clients. They're under pressure from their bosses. They're under pressure from their clients. They're under pressure from opposing counsel and from the courts. And it can really feel like there aren't enough hours in the day or opportunities, and certainly not enough dollars in the budget to get done everything that you need to do, that you want to do, and that is expected of you. And part of why this results in a lot of, I think, disheartened lawyers is because it feels like there's not a solution, right? And we want to tell you our holiday gift to you is some tips on litigation management. We really want to tell you things you can do now in your practice that can alleviate some of the pressure and stress and restore not only the joy of the season, but also a little joy to your practice. And we know this because our graduates tell us it has been uniformly true for them. And so we want to share a little taste of what that can look like in your daily practice. I am joined by my colleagues, Jim Wren and Kyle Dreyer, and I want to pitch it to you because litigation management's one of those things that people think they know what it is. They manage litigation, but it's not actually how we use that term. So guys, give us your thoughts on what litigation management actually is in this context of solving a common problem for lawyers.
You want me to jump in there?
Please do.
It is one thing that I have learned from years of practice and learned the hard way oftentimes is that there are lots of things that can go into managing litigation, but those things are not all equally beneficial or equally necessary. Yes, they're all helpful, at least in theory, to some extent, but some things are far more beneficial than others. Some things are frankly necessary that there's even a tendency to overlook the things that are most beneficial, even necessary. And so litigation management is the idea of approaching litigation with a framework where we are pushing to the top the key things that are most important to check off, to be sure that we are starting with, so that we're starting with a plan. And we can go into that, but the short answer from my standpoint is it is approaching litigation with a holistic framework where certain key things that are most beneficial, most necessary are getting done and getting done first.
Kyle, what about you?
You know, Liz, when you were talking about the problems that people face in handling litigation, whether you're a plaintiff's lawyer or a defense lawyer or you're in-house counsel, those problems really can be characterized, and I'm going to answer your question in the sense of there's too much, too little, and too many. There's too much time, it's too much money, it's too much waste, too much repetition. There's too many people, there's too many mistakes, there's too many rate increases. There's too little certainty, too little predictability, too little risk assessment, too little planning, a whole host of too much, too many, and too little. And so for me, litigation management is taking those problems and it is the solution to those problems because you are taking, as Jim said, the framework that especially Baylor puts, and you are teaching people how to better plan, perform, and perfect, as my good friend likes to say. Plan and perform and perfect. And that's what you're doing when you are managing litigation. Let me also say what litigation management is not. It's not taught in any law schools other than Baylor. And more importantly, it is really truly not taught within law firms or within client organizations. It's just simply not taught. It's needed, but not taught to address all of those problems that you mentioned, that I mentioned.
Well, if I were going to encapsulate it, I'd almost drop it into work smarter, win earlier. You know, just applying processes, thoughts, tools at the outset to get a handle on what you have. I swear, many of us find litigation to be like having a tiger by the tail, and we don't even realize that because we are forced into a reactive mode. And boy, I'd rather be, you know, on offense than defense when it comes to that. But I think that applying litigation management principles also lets you get to a win earlier, whether that is winning at trial or so many times getting to a better, more cost-effective resolution earlier is actually the win that the client and often your firm is looking for. So I think there's an element of that just encapsulates why litigation management for me is so important. And so, Jim, I want to start with, we promised some practical gifts. I want to start with something that I know is important to you and is a real foundational aspect of litigation management, and that's early case assessment. Be our Santa.
Okay, in brief terms, early case assessment is, and I'm a strong believer that early case assessment does not look the same for every docket. It ideally should be customized for the type of practice that a firm has or that an organization with in-house counsel is dealing with. But certain things are true. Number one, you need it. I can't tell you from experience, both in terms of how, going back more than 40 years ago, how I was initially trained or not trained, and how I have seen and talked to so many other lawyers even today, where the case comes in and we're going to start just firing off things. There is no early case assessment. There has to be. And what you really need is a process, a checklist, depending on the how large the case is, how the complexity of the case, the number of dollars involved. That process may be more in depth. It may be shorter. Again, it's going to be customized for the particular type of docket portfolio that you're dealing with. But it needs to be checking off what are the basic facts of this case so that we are quickly pulling together key documents, touching base with key witnesses that we have access to. We are getting the rendition of facts down, whether on the plaintiff side or on the defense side. Capsuled, what are our best facts? What are our worst facts? And boy, that second part is vitally important. What is the law that relates to this? What is the forum that we are dealing with? What are the opportunities in light of the facts, the law, and how this particular court approaches early dispositive motions? Is there an opportunity to get rid of this case or to prevail in a significant way, some particular aspect of this case with an early dispositive motion? What does the jury pool look like? What does the opponent look like, both the party on the other side and counsel, in terms of how they operate, whether they take cases ultimately to trial if necessary or not? And then what are we going to develop in terms of a budget and a discovery plan and a litigation strategy, negotiation strategy for this case? Now, if you're having to invent that as you're going along, it's very difficult to do it in any sort of consistent, uniform basis. On the other hand, if you have a format for it where it is just routine to check these things off, to acquire this sort of information and develop from the very beginning that plan for the case, which is, I think you'll probably want to ask Kyle about project management. nature of that. But having that early case assessment, and that is being done in the first 30 to 60 days that from the time that case comes in. You may not know everything there is to know about that case, but you're going to know about 85% of what you need to know about that case. And boy, that is getting you way ahead so that your plan is much more deliberate, much more functional, and much more likely to result in early resolution or getting the facts and the law, et cetera, that we need for the long haul, depending on what our client objective is. And by the way, client objective is a key part of that too. So having that sort of format, I think, is crucial to making the difference in terms of litigation success as defined by our clients.
Yeah, and Jim, I think that's such a good point. Not only that you have a systematic approach and engage in the discipline of doing that in the first 30 to 60 days, but that you also find meaningful ways to share that with the team who's going to be working on it. I mean, whether you have an online trial notebook, whether you have a software support system, whether your files are entirely, you've got to figure out who your team is so they have access to it. And also so that you're not sending people out to maybe track down documents or interview witnesses in a vacuum. You've
Right.
got to, in my view, also have an early team meeting talking about this case assessment process and getting it delineated, talking about metrics, and also setting expectations for timeliness, because that 30 to 60 days is really challenging in some scenarios. And I think it becomes a discipline that you just demand that in your cases. It may not be complete, we may not get everything, but I think that's really important.
But having that replicable front end system set up, and it gets easier, it gets quicker, it never gets easy, but it's far easier as you develop that within your firm or within your organization. And we set up these expectations, everybody knows it, they're already clicking on it. It is a huge front end difference in success in litigation.
Jim, we've been lecturing and talking with federal judges involved in the, multi-district litigation. And no matter whether you're a judge representing plaintiffs or representing defendants, one common theme that we're hearing is that good plaintiff lawyers know their case up front. If it's an MDL or something, you're getting it loaded in your database, you've already got that. But even if not, one of the problems with not doing that systematically is that it can really dilute the effectiveness of other people who have similar claims. It bogs down the class or the MDL, because you have a tiny number of people who actually know what their claims are worth and what they have, and a larger number that don't. I see all of this Camp Lejeune advertising right now, and in some ways with good reason, because we have some soldiers and families and vendors who were genuinely injured by something, and the government is making great strides to make it right. But thinking that you drove through the gates of Camp Lejeune is going to be sufficient to bring a claim is just short-sighted. So I think no matter, defendants have a little bit of this built in, because if you're working for a corporation or a carrier, they often have a structure for it. But even if not, just having one internally is really important.
There are several key differentiators between your best, most successful attorneys, plaintiff side, defense side, whatever, and those that are not at the forefront. And this is one of there are several key differentiators, but that process, that system for an early case assessment, that is one of them.
Yeah. And Jim, I want to ask you some more about other tools that you use, but Kyle, Jim had mentioned that early case assessment can help you with process and budgeting. Talk to us give us your gifts on how that can happen. And I'm very disappointed you're not wearing your Baylor Santa hat.
Well, I do have a Baylor shirt on, at least at this point in time. And I wish I had my Baylor Santa hat on. I could be giving real gifts. One of the things I think Jim's going to talk about it as well is this early case assessment, and there are features of that early case, other tools that you can use very early on that will enable you to have a better picture of what the case really truly turns on and what the value of that case is. And so, what I see is that people need to understand, and my gift is that you need to use project management and process improvement principles for litigation management. We need to learn from the business community. Us lawyers need to learn from the business community to use project management principles and process improvement principles in the management of litigation. And let me say this, that I have a hard time separating the word litigation management from effectiveness and efficiency. And I've read many, many times that effectiveness is really doing the right things, and efficiency is doing the right things in the right way. And if one wanted to add another E, you would say, excellent, that's doing the right things the right way and doing it every time. And so that's where project management principles and process improvement comes in. I said earlier that my good friend Jeff Carr calls it planning, performing, and perfecting. Well, planning is really the engagement, the early case assessment. When you get it from your client and you do that work early on and you are engaged with your client, think about building a home. You are learning what it is that you are building. And if you build a home, it's a project. So you're learning what you're building. What are the objectives? What are the key success factors from your client as part of this early case assessment, as part of the decision tree? I know that Jim will talk about, but that's the engagement phase. You are learning what it is that you're building. And then the planning sort of aspect of it is coming together with your client and understanding what is necessary to achieve the objectives. Not just willy-nilly start, but let's have a plan for how we're going to accomplish the building of this house or the client's objectives. And of course, that necessarily means you've got to understand what people and resources are going to be involved, what that schedule is going to look like, and what the time commitment is of those people to meet the schedule. I have heard repeatedly, Liz, and you guys know it. We heard it from people the other day. It's for particularly on the defense side of the docket. The conflict is there is expectation of reduced legal spend, and yet the defense lawyers have traditionally made money by billing by the hour, and they feel like that all of that work is being taken away from them. And so, how do I make a living as a lawyer representing corporate America? Well, the answer is in this planning phase to have a better understanding from your early case assessment and engagement with the client, what's needed in terms of resources and what the cost of those needed resources are. Needed resources is different than necessarily thinking you got to have the highest level associate or every partner on a case. You have to do a conscious thinking job, and perhaps, and of course I'm a proponent of it, in this process of planning, think about uh, alternative non-hourly billing sorts of things. So as you plan, then you move to the performing, and that's really the key there. And what we think is in the performance is that we do a good job of monitoring what we do. And the answer is we don't, because we don't have a methodology for understanding what we're doing and whether we're meeting the client's objectives or not in a timely fashion. That's why they communicate there's too many surprises. There's too many things they don't tell me. There's too many things I find out late because we're not really using the effective mechanisms to monitor what we're doing, having a good communication plan. So those are necessary ingredients. And then finally, I will speak to this perfection, and that is, this perfecting. That's the process improvement. That's sort of doing the things the right way. And we think that we know how to do things better. That's what people generally think. I think I know how to do things better. But what I think really is necessary is people need to be trained in what business people are trained in. the methodologies to eliminate waste, to eliminate mistakes, or I shouldn't say eliminate, to reduce mistakes, reduce waste, reduce bottlenecks. And there's literally 12 or 15 or 16 different methodologies that are specifically applicable to the legal practice, and that I would say the vast majority of people don't use. So my gift is, let's think about planning, and let's think about improving process. Let's think about performing and monitoring. That's the way I sort of look at it.
Kyle, I love that. And when you think about how this plays out, and I hope if you're watching this, you'll sort of think about the last case that you got in. What did your system look like when you got it in? What did you do? What did you find out later you wish you would have done? That front end loading is important, not only because it gives you a better sense of what do I have here, it helps you also figure out the economics of it. Because if you haven't really done, one of the courses I teach is proving and attacking damages. And I am astonished at how much time people will spend upfront on their liability facts without thinking about damages, which means they can get underwater so quickly because they outspend what their likely recovery, their best day recovery is. And so I love the idea of starting up front and soup to nuts, from liability to damages and jury charge, looking at what do we have here. Because if you've done that discipline, and I mean jury charge literally, draft your jury charge. It helps you even in drafting your petition, because the part where I think it helps make you more efficient is it gives you comfort that there is potential discovery you can choose not to do because it doesn't add enough value. When you talk about building the house, I see so many lawyers who send a bill every month to a client that's like, put framing up somewhere, ordered something for the bathroom, but not this systematic approach to it. And some of that, in addition to lack of early case assessment, some of that I think is fear that they're going to be the lawyer who didn't turn over every stone and then got burned by it. That can happen, but if you have done a thorough enough assessment, you are mitigating against the likelihood that it's going to. And I think that's so freeing, because you can say to the client, we are intentionally not doing this unless and until there's a reason to. And then you both have buy-in from the client, and you've got a written record of here's why this didn't happen if you're still just worried about malpractice. And I think those two things combined can be very freeing, both in terms of time and money.
Yeah, Liz, I'll tell you that one of the criticisms, one of the things you hear from corporate counsel these days is the absence of collaboration, the absence of the communication. And the reality of it is, lawyers don't need to turn over every stone, look under every stone. They just need to be able to say to the client, this is what we believe will get us to the critical success factors that you've set before us. And so we're not going to do this, and get buy-in and that collaboration and that communication. But if you don't communicate it, and if you don't have agreement on it, and if it's not a collaborative effort, that can lead to problems. Well, when you're planning and when you're setting forth how you're going to do your communication, those are the things that you address.
So Jim, you talked to us about sort of that systematic approach. And of course, after action review, a very important part of litigation management is, when it's all said and done, go back to that list. Did I have everything I needed? Did I do everything? Or have I learned lessons one way or the other that updates that? But that systematic sort of checklist isn't the only tool that helps with this. Talk to us, if you don't mind, about litigation risk analysis, decision tree analysis.
Okay. Let me put it first in a broader context and in a narrower context. The broader context is, if you go to Stephen Covey's famous 7 Habits of Highly Effective People, one of those habits is begin with the end in mind. You're already looking, where do I anticipate or want this to end up? And then with that in mind, how do I get there? Well, that's a big part of early case assessment. You are figuring out Where do I want this to end up? Where do I anticipate this will end up? And only if you're looking down the line, to go back first to the points that you and Kyle were making there, can you decide on one hand, what is less important that I don't have to spend a lot of time on? I can reach agreement with my client. This is not the main thrust of discovery. Yes, we could take all these depositions, but those are marginal. But there's a flip side of that coin. What is most important in light of how we anticipate, what we anticipate the jury charge is going to be, what we anticipate the jury is going to be most interested in, what are the key issues in this case? And that often opens up thinking about, unlike a different case that is something of this nature, but where the issues were somewhat different, unlike that case, this case, we really need to take a deeper dive on this theory, this type of discovery. And so you're simultaneously saying not so much of that, but definitely this, and you're making very deliberate sort of choices. Now to narrow down, and that's just part of a very broad thing of where do we want to end up, but to narrow that down, and this is not something I recommend with all clients. I recommend it with the more sophisticated clients, corporate clients often, business clients. And that is doing a more formalized, and that formalized does not mean it has to take a lot of time. Once you learn how to do this, it doesn't take a lot of time, but it's a communication tool where you're actually putting on paper, you're charting out a litigation risk assessment, and you're putting it in the form of a decision tree, but that's a little bit misleading. A decision tree is taught in business, as taught in military, as taught in healthcare, et cetera, is saying, okay, what are the different possibilities that I'm going to have to decide between, and taking the branches off of each of those roads and looking to see what decisions should I make. When you apply that, and there's a methodology for it that we teach, but bottom line, what we are teaching is not our decisions, but the decisions of the key decision makers in this case, and not our client, because we have, between us and our client, we have control over that. What we don't have full control over is what's the judge going to decide about this legal issue, what to submit to the jury, what is the jury going to decide about these key issues, and depending on which road maybe the judge takes on summary judgment, on evidentiary rulings, on Daubert motions with regard to a key expert, et cetera, this may or may not get presented to the jury, and then what can the jury do with that? Looking at those branches gives us a way to value the case. Now, the fact that we've got it charted out doesn't mean that it's right. What it really is a communication tool, so that, to come back full circle to what Kyle was talking about in terms of collaborating with the client and getting agreement with the client, it's a way to chart out, to quantify how we are getting to our assessment of the litigation risk in this case, whether from the plaintiff side or from the defense side, so that the client is seeing it, they're seeing our reasoning, they're seeing what percentages we're putting on the possibility of a judge deciding this on this question or a jury deciding that on that question. And they can disagree, others on our team can disagree. We can look to see what changing those probabilities would do, or those dollar numbers would do. What it's doing, it is a methodology with, and again, with more sophisticated clients, it is a methodology to communicate with our clients so that we're on the same page in terms of, we don't know what the outcome is, but we know how to quantify the risks so that we can make good decisions about what discovery do we want, how much discovery do we want, how much do we want to invest in motion practice, et cetera. It's a litigation risk assessment is a very good formalized assessment tool and communication tool with our clients.
Yeah, and I will say, for those of you who are watching and trying to figure this out, if you go back to our LLM webpage, we've done entire webinars on what this looks like. But think of it conceptually as, kind of the turning points in your case. Do you survive a 12b6 motion? Do you survive summary judgment? Do you survive a Daubert motion? Or for the defendants as well, how do you do on that? All the way down to, if we actually get to trial, What are my chances on liability? Is proximate cause or some causation issue going to be big? What about each of the elements of damages? And while many of us do this in our heads anyway, this forces you to identify those key points and then assign percentage likelihoods. I've got a 60-40 chance of winning on venue. I've got an 80-20 chance of winning on my Daubert motion. And it actually builds in numerical calculations that helps you with your estimated value of the case. What I will say is what's very helpful with sophisticated clients, I have used it as well in mediation and in settlement discussions. Because if I have the power of assigning to key events in the case percentage likelihoods, and I can justify that, now we're narrowing the conversation with the mediator, with opposing counsel, about the likelihood of those outcomes. And instead of that wasteful time frame where you're like, I've got a good chance of, or I think I've got a good chance of, now everybody is having to discuss their numerical assignment. And my experience is it closes the gap a lot, because it either exposes somebody making an assumption that's probably not well founded, down to, well, yeah, I put that at 10% and you put it at 20%. Okay, well, now suddenly we're narrowing the gap a lot. So I'm a big fan of this. And if you're not familiar, Mark Victor's sort of the guru on litigation risk assessment, but we've got webinars on it too.
And we teach it. Let me say this. This is so funny because when you bring up this, I think that risk assessment and decision tree is helpful helpful in getting a sort of the value for a case. I mean, obviously it is, but I think you can also take it and you can narrow it down and say, okay, these are the 7 witnesses that are important here. What's the likelihood that this witness's testimony is going to be good or bad and is going to impact my decision making, which can then guide your planning and guide your discovery, as Jim said. I want y'all to both know, and I probably hadn't even shared it with you, but I had a question come from a state district judge, a couple of state district judges, and they said, why is it that cases don't resolve early, and yet when the courthouse opens, they have a tendency to resolve? It's killing my management of cases. What do you think can be done? And Jim, what I suggested was require both sides to submit a decision tree to the court within 60 days of the case being filed. They can submit it in camera, but you have the opportunity to look at it at the close of the case after the case settles or goes to trial. Guess what? I bet you get some people doing some better work on their early decision tree if you do it. The judge laughed, but there's some reality to that, right? Because that's a frustration of the courts, and it's a frustration of lawyers too, right?
And Kyle, coming back to that point, the mirror, even if you don't have a sophisticated client, again, once you learn how to do this, you can do it very quickly. Just the mere process of doing it helps you isolate, the attorney isolate, what are the key pivot points, the likely pivot points in this case, so I know what I need to focus my discovery on.
Yeah, really agree. And especially when it comes to taking depositions, if you've got those key witnesses ranked in order of importance, I mean, some of them may well be your client or people in, your control, maybe you prioritize scheduling those so that you can update your early case assessment with better intelligence. I've had clients I met who were lovely people and I thought they'd be great witnesses, and vice versa. And then they get in the deposition and they're very different than my expectation both ways. And boy, knowing that up front not only helps you assess, should we be pushing towards settlement, but I think it also allows you to choose better and different resources. Okay, well, if it's not going to settle, then how do I improve the quality of this witness's testimony at trial? So I don't want you to think this all just happens up front and then you stop. It informs the process so you continue making these good decisions as you go along. And boy, is that important.
Yes.
Yeah. So, Kyle, you've talked a lot about applying some of these business processes. What are some good resources for looking at those? Because I didn't go to business school and I probably am not going to. Where can I find resources for ones that are good for lawyers that apply here and not just if I'm running a bakery?
Yeah, I mean, Liz, in terms of the process improvement methodology, let me ask it this way. There are certainly textbooks now that are out there, or books out there on legal project management. In fact, Susan Lamberth and David Roof, who authored a book on legal project management, are heavily involved in our LLM program. And we're grateful for their involvement in our program and helping train lawyers to use better project management principles. So, and there's other authoritative articles about project management. When it comes to process improvement and that methodology for perfecting what we do, or that after action review, there have been articles since probably the middle of the 1970s or 80s, when the automotive industry and the manufacturing industry began to change. There began to be articles that were written about eliminating waste, and about eliminating mistakes or reducing mistakes in the manufacturing industry. And then there are articles about lean, which is about the elimination of waste or reducing waste. There's articles about Six Sigma, which is a technique or a methodology to help reduce the number of mistakes. There's a number of methodologies that come from overseas, I think it's called a Gemba or a Gemba walk, that enables process improvement by speaking to those people who actually do the work to improve the process. So, some of those articles are available online, but I think it helps when you go through a program where you are learning about those methodologies, applying those methodologies to your particular practice, getting feedback on those methodologies or the combination of those methodologies in order to improve the processes, and quite frankly, save money and yet make more money at the same time. So, there's a host of articles that are out there about the 12 or 13. I've mentioned a few.
Yeah. Well, and I think your point is a good one. If you take a systematic approach to litigation management, you really need somebody to have combined all the resources for you in one place. You can certainly make improvement by reading this book or studying this or whatever, but it doesn't really tell you all the things nor do most busy lawyers. When we talked about the stress and the time and the pressure, saying, oh, I'm going to go out and find all the things and vet them to be sure I'm reading the ones that are of the best quality and not the ones that have really been debunked. I mean, that is a real legitimate challenge to learning litigation management. And I laugh at the number of times, if we ever had an LLM t-shirt, I think the slogan across the front of it would be, I didn't know what I didn't know. And I do think that's a huge challenge to trying to DIY litigation management on your own. You don't have the time or resources to pull all that together. You really need it curated for you, and in a way where you apply it immediately to what you're doing, where you can take your reading, and part of your homework is fix something in your process, fix something in your handling now, and then let's talk about how it works. So I think you make a great point in that regard, Kyle.
Well, Liz, I don't think that, when we teach methodologies and the variety of different methodologies, we don't teach them as saying this is exclusive, this is what you've got to use. Instead, we teach it from the perspective of this is what good people around the world have said helps them improve processes. This is what good people around the world have said help them improve not only their manufacturing processes, but their legal processes. And you're free to use whatever tools or techniques that you think will help you do what you're what you want to do. I mean, one of our graduates said, I need to reduce, he's an in-house counsel, I need to reduce my overall outside legal spend, and I've got to change some of my processes to be able to do it. So looking at what all he learned, took a combination of a variety of different things that he was taught and put them into practice immediately. And of course, we all know, I mean, he saw a significant reduction in his outside legal spend, all because he took that time, effort, and energy to take what he had learned and make application of it as he was learning it. Right.
Yeah, but Jim, that harkens back to something you said earlier, which was customization. Talk about how taking litigation management, and specifically the way we teach in the program, but even generally, talk to us about customizing it for your docket, your practice, your side of the V.
I mean, we're approaching it from a framework, and we're saying, okay, this framework we have found applies across the board, but that's what it is. It is a framework. It's focusing on what is right way, which is essentially saying much more can often, not always, but often much more can be achieved through collaboration, even with the folks on the other side of the table, as opposed to just knocking heads on everything while simultaneously pushing the pace. But there's a way to approach litigation. There is the right plan, which is part of what I've talked about here. There is the cost aspect. How do we manage cost? And that starts with that budgeting and monitoring it throughout, but having a plan for it. How do we approach the team, putting a team together that is right for this? How do we bring the right tools into the case? How do, the technologies and the processes that we've just been starting to touch on here? And then what are we negotiating toward? What is our objective, our client objective in this case? And how are we building all this toward the right result? What are alternative negotiation strategies, or if necessary, trial strategies to get this case beneficially formulated for the client? But that's a framework of things we want to be sure that we're considering. However, that looks different. The play out of that framework looks different for different types of practices. So what it is important to consider these various methodologies that Kyle has talked about, and you've talked about, and I've talked about, but pick and choose. Which ones of these really need to be emphasized for my kind of docket and for my organization, for my firm, for my, if I'm in-house counsel, for my company? Because it's not of equal, all of the possible approaches are not of equal benefit to everyone. So that customization, frankly, that's really what our program is saying, okay, here are the methodologies, we're introducing those, but then we're saying you need from the very beginning to start applying this to your organization, to your portfolio. And that's what most of our assignments are. Customize this particular aspect, evaluate it. Is this important or not so important from our organization? If it's important, how do we practically apply it? Not with the idea that there are right or wrong answers, there are just valid answers for the particular practice involved. So having on one hand, a framework, but on the other hand, having the recognition of importance of customizing it for your particular situation, your particular practice, your particular organization is absolutely vital.
Yeah, to carry on Kyle's building a house analogy, we're going to have a foundation and framing, but my brick house may not look like your stucco house when all is said and done. And that really brought to mind for me, we're so fortunate to have Chris Schultz, who's got, significant ties to the Sedona conference, and people like Violet Sullivan talking about data privacy. I mean, you think about with electronically stored information, knowing how to handle that foundationally is so important. Where is it? What is data? How is it stored? But it's going to play out so differently from case to case. It may be simply, identifying all the ESI in this small business, small dispute, getting people's text messages and emails and social media handled, all the way to massive cases with, you know, I hope not a terabyte of data, but
There could be
a
multiple terabytes.
massive amount of data, and you're going to be having discussions about how do we search it? Do we use AI in coming up with it instead of search terms? Who are the vendors? You know, that really is just foundational to where is my evidence and how do I have to deal with it in discovery and trial. It looks very different, but if you understand foundationally and how quickly our handling of data and ESI is evolving and impacting discovery, boy, are you ahead of the game, because there have been some scathing opinions out of some of the federal courts talking about how is it that lawyers do not understand fundamentally what data is and where it is stored, as simple as cloud-based versus server-based, et cetera, et cetera. So I think that's vital.
Yeah,
to the process.
it's not necessary in most situations that the lawyers who are managing litigation have to themselves turn into data scientists. But you've got to have a grasp of the concepts and the terminology and the possibilities so that you're able to communicate with those who are the ones that are taking the deep dive into the data. You're not sitting there just blindly taking their input without understanding what the real questions are.
Well, and Kyle, you've worked extensively with and for corporate clients. I mean, some of the decisions being made are whether it makes sense to centralize that handling of data and production of data in-house with a single firm, et cetera. Talk a little bit about that and why that becomes an important litigation management tool.
Yeah, it has gone through somewhat of an evolutionary process, you know. The first evolution of it was where the outside lawyers were doing the discovery and managing the electronic discovery, you know, almost exclusively. And then over the course of time, a lot of the handling of that electronic discovery, the searching of the internal documents and the different databases and the different computer systems and all that is internal to the client started to be brought, you know, in-house with help from outside counsel and the management, brought in-house either through in-house people or through companies that are brought in-house to manage that electronic discovery, you know. You know, then there's been an evolutionary process in terms of how you access the data, you know, whether it be originally, you know, it's, you know, eyeballs on with our paper discovery. And then it became, well, now we got all these computers, we need to be getting into search terms. And now, and, you know, then it becomes complicated because the search terms, we argued over what those should be and what they should, limits of them should be, you know. And now that, you know, more and more it's progressing towards, and because, you know, computers have gotten so sophisticated, it's progressing towards, you know, more and more the computer's going to do the search and be at least more and more largely accurate in terms of what they're looking for this large amount of electronic discovery. You know, one of the things I appreciate about our program is, you know, we have some you know, outstanding faculty that deal with that particular area. I mean, you mentioned Chris Schultz, you know, but we've had the involvement of people like, you know, BRG. We've had, you know, people that, you know, do that kind of work for both the plaintiffs and the defense side, who help our candidates and continue to help the graduates as they try to move through the complications of data and understanding data and how to access data and how to produce data. So
we actually had a couple of graduates find they knew so much about it, they went ahead and sat for the CIPP certification. Correct. Because they've learned essentially enough to get that. The Correct. Other thing that I think is important about litigation management is to appreciate how it continues to evolve and how much being aware of and immersed in that evolution provides a competitive advantage. we've had webinars we teach about litigation funding and the role it plays. I mean, 15 years ago, it was like, we will never use litigation funding for class actions or MDLs. And now, of course, what's the biggest source of funding for that? Judgment insurance, all of these different things that are evolving. So in the minutes that we have left, guys, talk about how really getting your arms around litigation management provides a competitive advantage. Because one of the other things we talked about as a real stressor is you've got economic concerns in your own firm, right? Here's the pie. How do you justify your divvying up of it and the share that you take? You've got other people vying for that work, whether you're on the plaintiff or the defense side. You've got courts looking at, should you be on the plaintiff steering committee or et cetera? How does this help alleviate some of that pressure specifically and give you a competitive advantage?
Well, I'll speak to that. By analogy, whether you're talking about by analogy, personal finances, whether you're talking by analogy about a business, you talk about virtually anything where there is a sense of competitive decisions to be made. It's the difference between a scattered ad hoc approach versus a intentional, very targeted approach. You're going to make better decisions. It allows you to make better decisions when you have a target that is fed by a framework. And so when you are basically being able to see the field as a whole, because you're looking at it with this framework, but now you're targeting it for your kinds of cases, your kind of practice, your organization, boy, does it inform your decisions. So you're deciding, where am I going to put time? Where am I going to invest money? Where am I going to not put so much time? Where am I not going to put money? And then being able to talk to that issue with your clients, with referring counsel, with the court, to basically provide a basis to, for example, be appointed to plaintiff steering committee and a MDL, whatever it may be. When you can very naturally and honestly show, I have thought this through. Here is the framework. Here's where we need to be focusing. Here are the decisions, the trade-offs being made. Man, does it make a difference in those sorts of communications.
Yeah. Kyle, final thoughts on competitive advantage?
Yeah, I would, I'm speaking at it from, obviously from Baylor's perspective, and Baylor's the only program in the United States of America in litigation management. And what I continue to hear from people, particularly for me, and given my experience on the defense side of the docket and from corporate counsel, is there is just a great demand for more effectiveness and more efficiency, and to lower the cost and the time of litigation while at the same time trying to make a profit. And I like to look at it and think the competitive advantage is the fact that through the program, you end up in a win-win. You can have both a reduced legal spend and also make money at the same time if you're on the defense side of the docket. And I guess I would cap it off by saying, I've heard recently from, significant in-house counsel, and the words are, if I had somebody who has the Baylor Law LLM in litigation management, given what my demands are and what my expectations are of my outside counsel and of my other inside counsel, versus somebody that didn't, boy, you're going to get in the door if you've got the litigation management master's degree, because I know you have done the things and you've learned the things that I think are necessary to be effective and efficient when I'm looking for lawyers, whether they come in-house to work with me or whether they are my outside counsel. That's a powerful statement of a competitive advantage from the defense side. And I believe that similarly on the plaintiff side, we've heard it from MDL judges, and we've, as you said, and we've heard it from others on the plaintiff side, that kind of approach, that effective use of the litigation management program can put you in a better position to succeed personally and organizationally.
So a couple of final notes. If we've piqued your interest, if you'd like the gift that we'll keep on giving, contact any of us to learn more about our executive LLM in litigation management. We'll tell you, but our graduates are so passionate about this, they'll tell you as well. But we'd love to talk to you about it. One of the things we spend a lot of time on in the course is how you put together and run an efficient and effective team. And so I want to give you a heads up. Our January webinar will not be in its usual Wednesday noon slot. It'll be on Friday the 13th, but it's not a trick and it's not bad. We have got nationally known expert, Dr. Jean Twenge, who has written multiple books, but my favorite of hers right now is called iGen. And it talks about managing, educating, working with this new generation, the generation that's never known life without an iPhone. She is going to be talking about that, but we're combining her with noted jury consultant Jason Bloom to talk about how does the generational divide impact you in handling litigation, picking your jury, choosing your themes. I am so excited about this lecture. It's actually part of our Dawson lecture series. Our last speaker for that was, the noted futurist Richard Susskind. So it is one not to miss. Mark your calendars. Have a marvelous holiday, and thank you for joining us.
Thank you.
Thank you.